Good morning friends, welcome to my channel Court Kautilyan. The case that we'll be discussing today, the name of the case is Meena Pradhan versus Kamla Pradhan. The case is actually based on a conflict that arose between Meena Pradhan and Kamla Pradhan. Meena Pradhan was the first wife of Bahadur Pradhan, and Kamla Pradhan was the second wife of Bahadur Pradhan. Basically, Meena Pradhan had two sons, and after divorcing Meena Pradhan, Bahadur Pradhan married Kamla Pradhan, with whom he had a daughter. So, the final judgment on the case was passed on 21st of September 2023. Now, what are the points that has been highlighted by Supreme Court that should be kept on mind while preparing a will? So, we'll be discussing all those 11 points which everybody who is preparing a will should keep in mind so that it finds legal approval if some conflict arises in future. So the first thing the court said that the court has to consider two aspects. Firstly, that the will is executed by the testator, and secondly, that it was the last will executed by him. It is not required to be proved with mathematical accuracy, but the test of satisfaction of the prudent mind has to be applied. A will is required to fulfill all the formalities required under Section 63 of the Succession Act. That is to say, the testator shall sign or affix his mark to the will, or it shall be signed by some other person in his presence and by his direction, and the said signature or affixation shall show that it was intended to give effect to the writing as a will. It is mandatory to get it attested by two or more witnesses, though no particular form of attestation is necessary. Each of the attestation witnesses must have seen the testator sign or affix his mark to the will, or has seen some other person sign the will in the absence and by the direction of the testator, or has received from the testator a personal acknowledgement of such signatures. D. Each of the attesting witnesses shall sign the will in the presence of the testator. However, the presence of all the witnesses at the same time is not required. For the purpose of proving the execution of the will, at least one of the attesting witnesses who is alive, subject to the process of court and capable of giving evidence, shall be examined. The attesting witness should speak not only about the testator's signatures, but also that each of the witnesses had signed the will in the presence of the testator. If one attesting witness can prove the execution of the will, the examination of other attesting witnesses cannot be dispensed with. Can be dispensed with. Where one attesting witness examined to prove the will fails to prove its due execution, then the other available attesting witness has to be called to supplement his evidence. Whenever there exists any suspicion as to the execution of the will, it is the responsibility of the propounder to remove all legitimate suspicions before it can be accepted as the testator's last will. In such cases, the initial onus on the propounder becomes heavier. The test of judicial conscience has been evolved for dealing with those cases where the execution of the will is surrounded by suspicious circumstances. It requires to consider factors such as awareness of the testator as to the content, as well as the consequences, nature and effect of the dispositions in the will, sound, certain and disposing state of mind, and memory of the testator at the time of execution. Testator executed the will while acting on his own free will. One who alleges fraud, fabrication, undue influence, etc. has to prove the same. However, even in the absence of such allegations, If there are circumstances giving rise to doubt, then it becomes the duty of the propounder to dispel such suspicious circumstances by giving a cogent and convincing explanation. Suspicious circumstances must be real, germane and valid, and not merely the fantasy of the doubting mind. Whether a particular feature would qualify as suspicious would depend on the facts and circumstances of each case. Any circumstance raising suspicion legitimate in nature would qualify as a suspicious circumstance, for example, a shaky signature, a feeble mind, an unfair and unjust disposition of property. The propounder himself taking a leading part in the making of the will under which he receives a substantial benefit, etc. In short, apart from statutory compliance, broadly it has to be proved that A. The testator signed the will out of his own free will. B. At the time of execution he had a sound state of mind. C. He was aware of the nature and effect thereof. And D. The will was not executed under any suspicious circumstances. So these are all the important points that you have to keep in mind before preparing a will. So I have read out the points that has been highlighted and given that has been included in the judgment. So what I'll do is that I'll even attach a copy of the judgment in my comment section so that you can go through the details of the case, because it's a very important case and it'll help you in your legal journey too. So subscribe to my channel, that is Court Cottillion. If you subscribe to it, it'll keep me motivated, and I'll feel more motivated to upload more such contentful videos in future. So support me by liking and by subscribing to my channel. Thank you.